Here we are, back yet again.
Sir.
Your evaluation says that the proper place is SATF, which is a treatment facility. I think that is the proper course.
No.
Okay. I know you say no, but that's what.
It's not about, I'm not, God damn, man.
Sir, no outburst, just.
Stephen, it's okay. You know, I mean, really, I get your frustration, but.
I understand, but the last time that we were here in court, it's not that I didn't go to take the UA. I couldn't submit when I went there. I came back to the courts were closed. I came to talk to you. As soon as we went out this door, Mr. Brooks and I spoke to him. I told him, I need to turn back around and talk to the judge. I said, I'm not going to be able to pass one right now. He said he'll talk to you, and he was going to come, and I don't know what happened with that conversation. He never got back with me. I still went down there to submit a UA. I was not able to submit one. I came back to the courts. When I came back to the courts, the courtroom was locked. I communicated that with Mr. Brooks. I'm not sure what the issue is, what the problem is with him and his communication, but it sucks.
That's baloney. And I'm going to call you on your baloney right now, because I know him. He's always been above reproach. It's not him, it's you.
No, I communicated
him under the bus.
I'm not throwing anybody under the bus. I communicated.
You're ingenuous, and it's just not true.
No, I did communicate with him. I promise. Why would I lie about that? I have no reason to lie. The same way that I told you the truth about everything, I have not lied about.
I have been dancing
for 2 years, exactly.
Since 3 years.
This case has been going on for 2 years. It's not a drug problem. It's not a drug issue. It's not at all whatsoever. And I swear to you on that, it is not. I can look you dead in the eye and tell you.
So what is it, Mr. Frazier?
There's nothing going on. There's nothing wrong. I'm just trying to continue my life. I'm just trying to do that's it. Honestly, that's really it. I'm just trying to just get this done with and continue my life. There's not a drug issue. That is the honest truth. And I don't know what else to say or how to communicate that to make you believe me. There is not a drug issue.
Okay.
I just want this case to be over with so I can continue with my life. I feel like it's been holding me back. I just want my life back. Just want my life back. I want it the way it was. I want my life back, but this is holding me back so much.
There's only one way that's going to happen.
It's not a drug issue, man. Please listen to me. It's not drugs. Please just listen to me. It's not drugs.
Mr. Frazier.
I don't have a drug issue. The last time we were here in court, they were the plea bargain that was on the table was to time served. What is wrong with that? What is so wrong with that?
If history is any indication.
I have never, ever failed a drug test ever since I've been in your courtroom.
You just don't go.
No, I have never failed one.
Just don't go.
That was the one and only time. That is the one and only time. Look it up.
Lower your voice.
Stephen.
No, Your Honor, I understand, but
sorry.
Lower his voice.
It's okay.
Sorry.
I get it. Emotions run high. But I'm going to tell you this, that you're probably one of the best actors.
I'm not
acting to this court ever. You put on such a show.
I'm going to take it to trial.
Okay.
I'm not, I don't.
For once, we're in agreement. Because I know that you don't want to go to the inpatient facility. So my recourse is to set you for trial.
What was wrong with the plea? What's the plea bargain?
I'm not taking it. I'm not going to take your just plea of guilty for you to get out. Because I know you get out, you're going to pick up another case.
No, I'm not.
And we're going to... Really?
So, I didn't pick up another case now.
Let's go through this now.
Okay, so that was then, this is now. When I did have an issue, but I don't have an issue now. And what I'm trying to do is just continue my life, and you're holding me back.
Ready? Can I go through this?
Go ahead.
Okay. So 6-3-24, criminal mischief. 12-29-23, assault bodily injury. Right before that in November, assault evading arrest. Terroristic threat, assault bodily injury. And on the terroristic threat, assault bodily injury, and on the VPO that you pick up right before that, I had to set the bonds at $30,004 because of all the times you took off and that you refused to take a drug test.
What drug test?
Threat.
Time out. What drug test? There's never, no, that's a lie. That's 100% lie.
Wait, this is where the whole case starts cracking. Couldn't submit UA. Excuse in court is never just paperwork. It's always a pressure point. The judge is already listening differently now.
What drug test? Go ahead. Call those out because I don't remember any of those.
Every case that you've had here.
There was not. Nope. That's a lie.
Let me finish or no?
Go ahead.
Every case since the first couple. You know what it was? It was with your first DWI that you came in here. That's when I started drug testing you. And since that point, it's literally gone sideways.
Never failed one.
After that, all you did was keep picking up cases, keep picking up cases, and you would never appear in court. So regardless, look, I'm not going to get into this pissing match with you. What's going to happen now?
Too, because obviously you're not in agreement and you just obviously want to have control. That's all it is. You want your way.
I'm going to have you go to the SATF program.
I'm not going.
Okay, I'm going to set your case for trial.
Thank you.
And if you're found guilty, then we do it as part of your probation, because I will. Is he looking at a year? Is he looking at, yeah, you're looking at a year. So what I'm going to do is I will sentence you to 365 days in jail. I will probate that for 2 years. And then I'm going to, as a condition of your probation,
Wait, what?
put you into the SATF program.
Why?
Because that's what I think you need.
What? So then 3 years later, you just take 3 years of my life?
The clinicians that assessed you
You're just
also
being,
thought.
no, because the first time they did not. It was not. They went with, they went against what was actually on there because they knew that that's what the judge wanted.
He's upset because, reality's a kick in the ding ding. I get it.
I'm not upset. I'm frustrated. I'm frustrated. This is going on way too long. I just want to get back to my life. That's it. I just want to get back to my life. That's it. I just want to get back to my life. Like, I don't know how hard that is to understand.
So, Mr. Brooker, I think that we just need to go ahead and probably set it and stop beating around the bush.
What is the offer that's on the table right now?
I'm not taking.
Well, I'm just asking, what is it? Okay, so what is it that you want? In all honesty, like, what all do you want?
I want you to go to the SATF program.
And what is that?
It's a substance abuse treatment facility.
And I have to wait a month just to go there?
The wait list right now is 3 weeks, but I can get it expedited.
We can expedite you in there as quick as possible.
What's expedited? Can I go tomorrow?
I don't know, Mr. Brooker. I mean, if I can get you there tomorrow, I will. I don't want to hold you just to hold you.
I want this over with. Just want this done with. I'm tired of this. I'm tired of this.
I want you to work the program honestly, though. I want you to do it well.
Just want this done with already. Like, I'm tired of this shit.
You need to understand that if you do well, the program will only be 6 months. If you don't respond well, it's going to be longer.
Program. I don't need a program. I'm not on drugs.
How soon can you expedite it?
I can give it a week.
You know what? And to update everybody and the entire world, you've sold me this story before, and now 1, 2, 3, 4, 5, 6, 7,
I've never told you this since the last.
This is later.
I've never picked up a case after I told you this.
I'm not playing this game with you again.
I'm not asking for any games. I'm not playing any games.
I'm sorry, Your Honor.
Sorry. I'll
Stop.
Okay, I'm setting your case for trial today.
Can I do the, stop.
Your Honor, I'm sorry.
Let me talk to him real quick.
Okay.
Is discovery complete?
On the ABI, yes. On the mischief, I'm missing some. I'll subpoena it, but we can
Can you
set it.
please get on?
The offer was originally, it was
I'm not taking, no.
13-month deferred with TRAS and RUAs and no drugs. That was the offer before the 30 days. So that's still on the portal. You were asking
And
about
Chief, what case would you go forward on?
At this time, it would be the ABI, unless I get discovery, the surveillance on the mischief at that point, if it's made available in time.
Who's the mischief against them?
It's a Walmart.
Oh, that's right. He goes in there and
He breaks
breaks a
laptop.
computer.
Yeah, because he was using it for his personal stuff and got mad at it. That's allegations.
So I don't know, Mr. Brooker, if you want to reach out to Mr. Fraser now and look, they've said they're offering you a 13-month, you say deferred?
Deferred, yes, sir.
This repetition is doing the opposite of what he thinks. it's raising suspicion. In court psychology, over-explaining innocence can actually weaken credibility fast.
TRAS, RUAs, no drugs or alcohol.
The TRAS is already done.
Well, it's TRAS and conditions, so the conditions,
So-
what it suggested was SATIF, so that would be,
This was a mental health underlying.
So
yeah.
So remember your composure.
this is the offer. The offer is a 13-month deferred, which is a type of probation that if you complete successfully, you don't end up with a conviction. That is on the assault. They will dismiss the criminal mischief. As part of the probation, though, you will be doing the substance abuse treatment facility. That's what we're asking you to do.
Can
And
I
if you
do
want to
something?
take that, you can. You don't have to, but if you don't, I'm going to set your case for trial. We will go on one or both of the trials, and on one of them, whichever one you're found guilty, if you're found guilty, you will go to the SATF program.
Is there any way that I can take substance abuse classes while on probation and do that, like an outpatient while on probation instead of going to SATF and then do?
No.
I don't understand why
I
not.
know you want to get out, but if I let you out and try to do the substance abuse thing outside, you're not going to do it.
If I'm court mandated, yes, I will.
No.
How do you? I did everything else.
Because you take off on me now when I let you out now.
I didn't take off. I
Yes,
did
you
what I
did.
had to do. I went down there.
I'm
I
not
didn't
going to
take off.
pissing match with you
I
again.
did not take off though.
You either take it.
I did not
But you-
take off. I showed up to court exactly on the 29th, exactly like I did, like was requested. I showed up.
Serenity now. Mr. Frazier,
Showed up.
you know what the deal is. They've offered you the deferred. If you want to take it, you can do it, and we can try to expedite you into the SATF program. If you don't want to do it, we'll just set your case for trial, and we'll do it the long way. So,
What would trial do?
I don't know, 30 days at least. Because he's got to subpoena witnesses. I have to give him time to subpoena witnesses. So at the fastest I could get you in for trial is 30 days.
This is
But I'm
ridiculous.
telling you this, I'm going to go to trial on the assault. I don't know what's going to happen.
Oh, I know
If
for
you're
a
found
fact I
guilty on
never
the assault,
assaulted
if you're
anybody.
found not guilty on the
I know
assault,
for 100%
I'm going to
fact.
go, we're going right then and there, right after, we're going to right trial on the criminal mischief.
That's fine.
One right
I
after
know
the
I
other.
didn't assault anybody.
Okay. Well, then I can't take anything from you then if you're telling me you're not guilty.
And how long will it be until I can go into the status program?
Well,
It'll be a week if I can expedite it.
a week.
Just today's Friday, so.
And I'll order them to expedite it so that we can get you in a week. And then when you're in the program though, like I told you, if you're acting like this to me, like you are to them, what do you think is going to happen?
So what is it? What type of facility? Is it like in jail or?
It's a treatment facility where you're going to meet with people on a regular basis
Well, I'm
to
saying
talk
it's still
about your
jail?
issues.
Is it a program? Is it a facility or is it jail?
You're housed in a different facility, okay? Is it in Atascocita? Where is it?
It is, it's in the text.
So you're housed not in the jail here in downtown. They take you to a different facility, but you're not just free to leave. It's a different facility where it's rehab essentially, right? You're taken to a different facility. You meet with people on a regular basis to talk about substance abuse issues. They will routinely drug test you. And depending on how well you respond, it could be 6 months, it could be 9 months. If you're butting heads with me like you are now, it's going to be longer. It'll be a year and a half. Take your time.
No, it's fine. I'll take it.
I want you to think about it though.
Fine, I'll take it because the longer I have to take, the longer I have to stay here. I don't want to be here.
Okay? You're ready to do it? Then I'm ready to do it with you.
It's fine.
And I'm going to tell you now, I'm going to go visit you in Atascocita. I will personally go there to check on you to see how you're doing. Because we can do that. And if you're not doing well, they're going to end up filing a motion to revoke your probation, and we're going to do it all over again. So I wanted to take.
Boom. That line, you put on such a show. is the judicial version of calling someone's bluff. At this point, trial isn't just an option, it's a warning shot.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On September 8th, 2024, the officer was contacted by a witness who advised he observed the male sleeping in his truck at North Wayside Drive and East Freeway in Harris County, Texas. The officer observed the defendant's vehicle parked at the location with the engine running. The defendant was going in and out of consciousness in the driver's seat with the keys in the ignition. The officer observed a 12-ounce Modelo beer in the center console, and the defendant admitted to drinking. The officer
Alcohol in the car while he's driving.
Yes, Your Honor. And the officer observed poor balance, slurred speech, glossy eyes. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, and one leg stand 3 out of 4. Defendant was read DIC and refused breath. Blood search warrant was obtained and executed. Defendant was identified with his Texas driver's license.
Can you crack the eyes?
No, Your Honor.
Mr. Figueroa, I want you to understand that I'm going to do everything in my power to protect this city. If you don't believe me, ask Yasha. I put one of his clients in jail yesterday. And as unhappy as they were about it, I don't give a rat's behind. I don't care if I offend you, if I offend all of America because I don't coddle. You're so naughty. I don't care. You have alcohol in the car allegedly while driving. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. And if I find that you do, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time your happy ass gets into a car and drives. Do you understand?
Sure.
I hope that you would understand that it's elementary that you're not supposed to have alcohol in the car. And now you're going to pay a very dear price, because I'm going to tell you, living in a city as big as Houston without the ability to drive really, really blows. And now, until I know that you absolutely appreciate the awesome privilege it is, because it's not a right, it's a privilege. If you drive, you'll be facing 6 months every time you drive. I'm also ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using any kind of alcohol or dope, likewise, you will go to jail. I'm not going to give you any more PR bonds. So if you go to jail, you'll be stuck like Chuck in there until this thing is over with, unless you have someone to bond you out. You understand? Okay. Yasha, until I know that he absolutely appreciates it, and I want some kind of proactivity to know. So until that point, no driving. That's it. Okay. So
Whatever I can do.
you also need to understand that having alcohol in the car, it's a minimum of 5 days in jail to any sentence that you get. 5 days flat. 1, 2, 3, 4, 5. No 2 for 1, no 3 for 1, no credit. Do you understand? All right. Sign this affidavit. After that, we'll get you to Victoria to sign a reset. After that, you'll get with Rachel for your bond conditions, and we'll put you on your way.
Yeah, thank you,
Okay.
Judge.
All right, Judge, page 20. Wilson, come on up. Yes.
No just motion to sub today, huh?
Not today.
Wonderful. Good morning.
Good morning.
And who do we have here?
Marissa Wilson.
Good morning, Ms. Wilson. All right, Ms. Wilson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On September 7th, 2024, officers observed defendant's vehicle traveling 35 miles per hour in a 60 miles per hour zone between 7400 and 8400 block of Katy Freeway in Harris County, Texas. Officers observed defendant also almost hit an 18-wheeler traveling to the defendant's right.
Notice the shift. Now it's urgency versus system delay. Can I go tomorrow? Is not just a question, it's desperation trying to outrun consequences.
The defendant almost swerved into another passing vehicle. Officers observed the defendant's registration to be expired as of November 2020, and a traffic stop was initiated. The defendant came inches from hitting the freeway wall while exiting, and the officers made contact with the defendant, the driver, and sole occupant of the vehicle. Officers observed a strong odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant stated she was going home and had 5 alcohol. And was 4 at 4. The defendant read his DIC and refused breath. Officers located a half-empty 750 milliliter Jägermeister in the defendant's vehicle. A blood search warrant was obtained and executed. The defendant was identified by her Texas driver's license.
Did you say initially, did I hear you that you said she had a suspended license?
She had a registration expiration.
That's what it was, okay.
Yes, Your Honor.
Where was the Jägermeister? Was it within reach, so she's drinking while she's driving?
I'll check, Your Honor. Let me read the OR.
Yeah, take your time. While he's doing that, Miss Wilson, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using anything, I'm going to put you in jail. You will not get any more PR bonds, ma'am. You have a valid Texas driver license. You're not allowed to drive. And I want you to understand that I don't think anything makes me more upset than we have people driving like boneheads out there without a driver's license. And I'm going to tell you now, if I find that you drive, I will bring the wrath so hard that I'm going to sprout horns in the tail. That's how upset I'm going to be.
The OR just says inside the defendant's vehicle was a half-empty bottle of Jägermeister. It doesn't say where specifically.
Okay. Miss Wilson, you will be signing an affidavit with me today. I don't care what's going on in your life. I don't care if there's an emergency. There's nothing you can tell me that you can justify getting into a car and driving whatsoever. If you want a license, or if you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, don't do it. I don't care how tempted you are. Let me ask you this. I asked you if you have a Texas driver's license. Do you have a driver's license from anywhere else? Okay, then that's what all right. I'm gonna have you come up here, swear to us that you're not gonna drive. After that, I'll get you to Victoria. We'll have you sign a reset. You'll get with Rachel for your bond conditions, and then after that, you're free to go. No drinking. Don't drive. Okay? Thank you.
All right, Judge, page 1, Cabasas.
No, we're going backwards. Abbas, come up.
I'm sorry, is it 12?
The one in Turkey.
No, it's not. It's not. It most certainly is not. It's a morning. Good. I guess that's a matter of perspective. You tell me here in about 5 minutes if it's good. Mr. Abbas, you picked up a new case while you're on bond. You're now charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 9th, 2024, officers were dispatched to 3506 Fern River Drive on a call for stating that the defendant was banging on the door and refusing to leave. The defendant was sitting on the porch when the officers arrived, and the defendant stated he was arrested the other day for criminal trespass at this location, and he wanted his phone and keys back. The officer knocked on the door of the residence and did not get a reply. The officer told the defendant that he should not be at the residence, and the defendant began to walk away. Officers reached out to the complainant via cell phone, and the complainant and a witness came to the door. The complainant, the homeowner, and mother-in-law.
This is the hammer drop moment. Not a warning anymore. This is judicial enforcement mode. The court is no longer negotiating. It's controlling behavior.
Of the defendant stated she did not want the defendant on the property due to him being a drug addict. Officers returned to his shop and discovered that the defendant had returned to the scene. Officers detained the defendant and was given a trespass warning.
So let's go through the timeline. He picks up. Okay, so he picks up an interference and then a felony possession case, right?
Yes, Your Honor.
Gets out of jail, it goes right back.
Yes, to the residence, yes.
Had we ordered him not to go back?
If you go into the bond conditions, let me see what was ordered.
I mean, regardless, he picked up a new case.
He did pick up a new case while I'm
So, guess what happens now that you picked up a new case? Want to take a guess?
I have no clue. I have no-
Take a guess. You should be able to hear it behind you. I am now revoking your bond and I'm taking you into custody.
Judge, I would like to say is that,
There's nothing you can say right now. You picked up a new case and I told you not to pick up a new case. So he goes with you. I'll appoint your lawyer now. You can tell the lawyer. It's not a good day though. Okay?
All right, Judge, page 5. Coey?
So 5,001 on the interference and then ixnay on the PR bond A on the criminal trespass A. A. If they give him a PR bond. Let's see. Yeah, they give him a PR bond, so no dice on the PR bond. Shitoria, can you give me a solid? Set him up there, T-Rans, please. On Abbas, please. Vic, what page?
This one is on page 5, top of page 5.
Thanks.
C-O-H.
Kohea. Mr. Kohea, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 5th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed, 89 miles per hour in a 65 mile per hour zone at 3900 block of East Sam Houston Tollway in Harris County, Texas. The officer observed the defendant's vehicle swerve through traffic to maintain high speed and move from lane 2 to lane 3 to lane 1 in a reckless manner without signal, causing other vehicles to brake. The defendant's vehicle came close to colliding with other vehicles while changing lanes when unsafe to do so. A traffic stop was initiated. Officers made contact with the defendant, the driver, and sole occupant of the vehicle. The defendant was ID'd with his Texas driver's license.
Mr. Kohea, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Do you have liability insurance in your name? I want proof before you leave here for today. Otherwise, I'm not going to let you drive. I'm making it a condition of your bond that you not participate in any more reckless driving, street takeovers, racing, boneheaded moves of this nature. Otherwise, the first thing I'm going to do is I will take away your privilege to drive. The second thing I'm going to do is I will put you in jail, just like I did this past person. Do you understand? Do you mind filing those conditions, please? Cohea. Cohea. C-O-H. No reckless driving and all that jazz.
And there it is, the turning point. That silence before custody is always louder than the ruling itself. Once bond is revoked, the narrative completely resets.
Reckless driving, racing, street takeovers, etc. For now, I'm going to have you go to Victoria. I'm going to have you sign a reset. After that, I'm going to have you take a seat in the jury box while we wait for your lawyer to get here.
All right, Judge, next is page 5, Cormier.
So on this gentleman, it's Jason Johnson, his lawyer. So when Mr. Johnson gets here, I'd like to see if he has insurance. Otherwise, there's no driving affidavit. Yeah, hold on it. Mr. Cormier? Mr. Cormier, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Oh my goodness. He's charged with 2 FSRAs.
Yes, Your Honor.
You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On September 7th, 2024, officers were dispatched to an FSRA call at 1220 Brickmore Road in Harris County, Texas. Officers flagged down by a witness who pointed the officers in the direction of the defendant. The officers made contact with the defendant, who was trying to take items out of the trunk of his vehicle. The defendant stated that 2 cars hit him, that he turned off into a private drive due to a busy street, that he lost control and went into a ditch, and that the vehicle belonged to his mother. The defendant stated he was not drinking. The defendant later stated he had one 16-ounce Bud Light, but that he was not drunk and he was good. Standard field sobriety tests were administered. HGN 4 out of 6, walk and turn 2 out of 8, and 1 leg stand 3 out of 4. Defendant was read DIC and consented to breath. Results were .148 and .131. Defendant was identified with his Texas driver's license. And officers made contact with the 3rd complainant. The complainant stated the defendant's vehicle came from a side street, and the defendant struck his vehicle, and the complainant complained of wrist pain. The damage to the 3rd complainant's vehicle was approximately $20,000. Officers made contact with another complainant. The 2nd complainant stated the defendant's vehicle took a U-turn, struck his vehicle, and the complainant complained of pelvic pain and head pain. The motor vehicle damage to this complainant's vehicle was approximately $30,000. The 3rd complainant, the 1st complainant's passenger, complained of rib pain.
See if he has any prior DWIs.
He has no prior DWIs, Your Honor.
Mr. Cormier, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license? Oh my God. Tell me you have liability insurance.
My insurance policy just went up in August last month.
Do you have? If I send you now for a drug test, what's going to show up? I'm sending you now for a drug test, and you must come right back. If you do not come back, your bonds now are, I'm in shock that your bonds are only $3,000 on your these are 2nd degree felonies, right?
These are basic. 5 years.
Say it again?
Yeah, it's one of those hybrid felonies that's got a punch rate of up to 5 years. So I'm not quite saying.
I'm sending you now for a drug test. You must come right back, Mr. Cormier. If you do not come back, I'm going to set your bond at around 10 times what your felony bonds are at. Do you understand? At that point, we're going to go forward. But I'm ordering you now as a condition of your bond not to drive. If I find that you drive and I don't give a rat's behind what you're doing, I will have a contempt hearing. You'll be facing up to 6 months in jail and or a $500 fine every time you drive. Do you understand? I don't care what your excuse is. I don't care where you're going. I don't care if Jesus needs to ride to church. You drive, holy moly, I'm going to light you up like you've never seen before. I want him to go take a drug test right now, and then we'll have him come right back. I'm going to have you sign a reset. Hold on. Before he leaves, I'm going to have him sign this affidavit so I can hold his ass in contempt if he tries to drive. All right, I'm gonna have you come up here, swear test or shotgun drive. I'm gonna have you sign a reset and go take a drug test. So this is Mr. Cormier. This is the one where that we have at least, is it 3 people that were pretty badly injured, right? At least 2.
Yes, sir.
Okay, Mr. Cormier, I don't want you out in the middle of the night. I'm now gonna put an ankle monitor on you so that I know that you're not out in the middle of the night. On one ankle, you're going to get a monitor, so I know that you're not consuming alcohol. On the other one, you're getting a GPS monitor, and I'm giving you a curfew of 9 p.m. to 6 a.m. If I find you out, I'm going to lock you up, and I'm going to make your bond so very high, it's ridiculous. Do you understand? I will do everything in my power to protect every person of Harris County, and if that means locking you up at $100,000, I'll do it in a heartbeat. Do you understand?
So,
Do you work? When is the last time you've had a job? What were you doing?
solar company.
Why did you lose your job?
Just HR problems. Problems with HR. About my performance and crime.
Okay, it's time for you to get another job.
So,
I'm now also making that a condition of your bond. I want to know that you're working, not out doing nothing. Too much time on your hands, you become self-destructive, and I'm not going to have it. So I'll appoint your lawyer today, Mr. Cormier, but I'm bringing you back in 2 weeks, and I want to know what you've done to get a job. If you've done nothing, it's just not going to go well between you and I. So take a hint. I'll have you sign, or he's already signed a reset with you. So for now, I'm going to have you sign your conditions with Rachel. After that, I'm going to have you take a seat in the jury box while I find your lawyer. All right.